Yes, it certainly is, Matt. And today the court ruled that both Harvard and the University of North Carolina admissions processes that consider race of all applicants is in violation of the Equal Protection Clause of the Constitution and therefore unlawful. So the Equal Protection Clause is intended to stop discrimination on the basis of race, among other things. So I'm here now with Subodh Chandra and also Case Western Reserve University law professor Jonathan Adler. They're here with me now to talk through this ruling today. So I'll start with you first, Mr. Chandra. What do you think about these considerations at places like UNC and Harvard, striking these down? Is this in line with upholding the Equal Protection Clause?
I think the challenge that we have here is that this decision is actually diminishing from the intentions of the Equal Protection Clause, which was to create a vehicle for equality of opportunity. Post-Reconstruction in this country, that's what that amendment was all about. So I think when you take such a formalistic view and you almost take the attitude that race can't be a consideration at all, what you've done is undermine that vehicle for equality of opportunity.
Professor Adler, I'll ask you now, what are your thoughts on this?
Well, I think when one looks at the specifics of these programs and the extent to which race was used, and in particular the extent to which it appears to have disadvantaged Asian applicants, it's hard to square that both with the Equal Protection Clause and Title VI of the Civil Rights Act, because it appears to have been a serious negative to the ability of at least some groups of people to be admitted.
And that is in line with what the court was saying in here. Now, we talk about this court. This was a 6-3 decision in the UNC case, a 6-2 decision in the Harvard case in which Justice Ketanji Brown Jackson was recused from that case. So this was a vote along ideological lines. We're looking at a court now that is more diverse than it's ever been. Is there anything surprising to you about this vote, Professor Adler?
The vote wasn't surprising. I think one thing that is interesting and surprising about the decision is that for the last 45 years or so, we've talked about diversity in higher education as a justification for the use of race. No justice really wanted to defend that rationale. The dissenters more wanted to talk about the history and the purposes of the 14th Amendment and goals of racial equality, which is something that for the last 45 years, the courts have said you can't use as a basis for considering race in higher education.
And Mr. Chandra, what are your thoughts on that?
Well, I think you look at the opinion and there's a little glimmer of hope for those who want to ensure that there's greater diversity in higher education so that we all get that exposure in a cosmopolitan society. And that glimmer is that the court was focused on whether the particular programs at issue were narrowly tailored. And Chief Justice Roberts, for example, invited a conversation by applicants to talk about the impact of their racial background on their development. So I don't think the court is completely shutting down any consideration of race. But what they do seem to be saying is that making that a primary consideration is impermissible under the Equal Protection Clause.
Okay, thank you both for your expertise today. And as we send it back over to y'all in Studio B, I'll just mention that what we did see in reporting today to you, Matt, is that this will vastly impact the most selective admission processes, and maybe they're saying maybe not so much at the universities that don't have such selective admissions processes.